I would just like to express, Your Honor, how dangerous of a situation this was. 4 times the legal limit, it appears, and when the police did pull in front of him to stop his vehicle, he attempts to pass them six times and eventually drive into a field.
This case starts with danger on full display for times the legal limit, reckless swerves, and officers nearly rammed off the road. We're diving into sentencing for resisting police and reckless intoxication. Stay tuned, because the judge's decision packs lessons about accountability. Subscribe for more dramatic courtroom breakdowns you can't miss.
Have you had a chance to review the report and information?
I have, Your Honor. We have no factual additions or corrections, and there are no challenges to the scoring of the sentencing guidelines.
And Mr. Ryan, the advisory guidelines are 0 to 11. Any additions, corrections to the report, or scoring challenges from the people?
No, Your Honor.
All right. I did receive on Friday, Mr. Voida, an indication or a request from the prosecutor's office to notice up a show cause for contempt for today for an alleged missed test on the SoberLink in August and a positive test, a slight positive back in May. I declined to issue the show cause for lack of notice for today, but I did want you to be aware that then I guess based on that report, I am considering as a probation.
The judge raises the possibility of a SCRAM, tether and ankle device monitoring, alcohol intake. This isn't just punishment. It's about protecting the public from another dangerous night. Question for you. Would you trust this technology as a safeguard, or does it fall short of true accountability in cases like this?
Term switching him to the SCRAM tether for a while. So if you want to address whether you think that's appropriate or not, go ahead with any allocation.
Thank you, Your Honor. We've reviewed the recommendations, and taking in light, Your Honor's, the information from the court just now, we're in support of that. A SCRAM tether would be good. It has been a good method of accountability for my client to use SoberLink for the last 10 months, and he's done very well on that. You've seen in the recommendations in the PSIR that my client is employed, has stable employment, has family support. He has all the motivation in the world to keep himself afloat. What you don't see in there is that he's made amends with Deputy Rabeau. He's known Rabeau for years, and after this incident, he was mortified by what he'd done and has cleared the air, had a conversation, and apologized to him. And it's my understanding that apology was accepted. And so he's taken personal responsibility, person to person, and now to this court for what he's done. And he's shown you over the past 10 months what he's capable of doing when he puts his mind to it. He's a capable guy. When he's sober, he's a heck of a guy to know. And the goal here is to keep him sober. We think those recommendations appropriately take that into account, and we'd ask that you adopt them.
Great, thank you. Mr. Tolgetska, it's not required that you would say anything today. If you don't, I certainly don't hold that against you, but you're also allowed to make a statement. Anything you wish to say, sir?
I'd just like to apologize on everybody's behalf and to law enforcement. And my judgment that day was impaired. And
there it is. The judge fires back hard. At those speeds, this could have been deadly. His reminder is chilling, telling families, "That wasn't me that day," doesn't erase tragedy. This raw contradiction shows how courtroom reality cuts through excuses, exposing the true stakes behind impaired decisions on the road.
that police report, that's not me, if I'm sober. So I'd just like to apologize. And like I said, I did personally apologize to Officer Rabeau that I've known for a long time.
Okay. I hope you understand. I mean, at the speed you were driving and the level of your alcohol, you could have hit and killed somebody, and then it would be cold comfort to their family that, gee, that wasn't you that day. So you being sober is a real important thing going forward.
Sure.
Mr. Ryan?
I would just like to express, Your Honor, how dangerous of a situation this was. 4 times the legal limit, it appears, and when the police did pull in front of him to stop his vehicle, he attempts to pass them six times and eventually drive into a field to his father's house. I mean, just the sheer danger that these officers were put in, and if anyone was on that road or in that field, I do think that jail time is appropriate in this matter. Maybe the lower end of the guidelines certainly, but I just think it's such an unacceptable and dangerous scenario that these officers were put in.
Thank you. Well, Mr. Tilgetska, you're here today. You have no prior felony convictions. The guidelines do call for what the law calls an intermediate sanction, which means I have to start with presumption of probationary sentence without incarceration unless there's reasonable grounds for it. I mean, the prosecutor's right, that's a close call whether that's present here, because your driving behavior was pretty dangerous here. The sentencing offense is resisting, obstructing police, so that the sentencing guidelines of 0 to 11 apply to your refusal to exit the vehicle. The fleeing and eluding charge was dismissed. And the drunk driving charge, although this was, as I've said, a very, very serious and dangerous drunk driving situation, it is a first offense for you. So the drunk driving is a misdemeanor offense. You have been on bond sometime. I'm not sure. As I look at that report I got, I don't see major problems on bond, but I don't have confidence of whether you were trying to do any maintenance drinking or not. So I will include a SCRAM alcohol tether for the first for a minimum the first 30 days of probation, and then it can be removed at your supervising agent's discretion. But I think all those things together mean that I will follow the recommendations of the Department of Corrections for a probationary sentence of 18 months.
Here's the turning point: 18 months of probation, mandatory treatment, and financial penalties. The judge balances danger with rehabilitation, emphasizing sobriety as the true sentence. No jail this time, but with SCRAM monitoring and strict conditions, the consequences still carry weight. It's justice that straddles punishment, deterrence, and second chance accountability in action.
You are eligible for discharge early at the halfway point if you've successfully completed all required programming. We're going to hand you a piece of paper explaining that process. You're on probation. You're going to be subject to the terms and conditions listed on pages 2 and 3 of the pre-sentence report. I want to highlight just a couple for you. You have to complete a substance abuse assessment and any treatment as referred by your field agent. You have to seek and maintain full-time employment. There is some financial assessments, $118 in state costs, $130 in crime victims assessment, $350 in court costs, restitution of $250 for the OUIL reimbursement, and a fine of $250 on the drunk driving charge as well. I guess the probation order, can we put them on probation for the misdemeanor too, or felony? Yeah,
The felony, Your Honor.
So the probationary order will only include the felony count. I think that covers what, though the rehabilitation goals will be substance abuse treatment and to address the needs identified in the COMPASS assessment. In order that you serve 4 days in the Prescott County Jail and give you credit for 4 days previously served. So, Mr. Tilgetska, that's the sentence of the court. If you wanted to appeal, you'd have to file an application to the Court of Appeals. If you wanted a lawyer appointed for you, you'd have to request that within 42 days and qualify. We're going to hand you a piece of paper explaining those appeal rights as well. Ask you to initial one copy for us, and the other one is for you to fill out if you want to take an appeal.
The gavel falls probation, treatment, and community safeguards instead of prison. A near disaster avoided, but justice insists on structure and sobriety. This courtroom reminds us every choice behind the wheel matters. What's your take, fair? Mercy or too lenient? Like, comment, and subscribe for more shocking courtroom stories and breakdowns like this.